Good morning. How's everybody doing on this Tuesday? Oh, good. Excellent. All righty. So today is Tuesday, July 16. We have 4 cases on the docket. 3 is scheduled to argue this morning. The first case we have, which is the first case to argue, is case number C230389, General Electric Credit Union versus Harold Sosna. If attorneys can please identify themselves in the readiness to proceed.
William Fecker for appellants Harold and Faye Sosna. We are ready to proceed.
And it's Sosna?
Sosna.
Okay. Kind of like salsa except with an N in there. Sosna. Got it.
And Shannon Egan for the appellate Fifth Third Bank National Association.
All right, thank you. All right. And then the next case we have is case number C230566. I'm sure I'm not going to get this one right, so feel free to let me know. Tochard versus Rumpke Sanitation Landfill.
The state of Carl Towner and Robert Chani for the state.
And how do we say the last name?
Talbert.
Towkert, thank you.
Mike Capital, Sarah Geiger, Michael Gallagher, somebody at the Rumpke Sanitary.
Okay, I know I got that one right.
Yes.
All right. Okay, the next one is case number C230448, S&T Bank versus Advanced Merchant Services. And I know that we have, actually, that's right, this is the last case we're arguing, then we have one that's submitted on the briefs. I know we have, let's see, 1, 2, 3, 4, 5, 6 for appellee, right? All right, so for appellant,
Jonathan Ellis, Grayson's.
all right. Are you dividing time?
No.
Okay, so who will be arguing this morning? Okay, thank you. And for appellee, we have Mr. Truitt.
Yes, Daniel Truitt on behalf of the iSource employees.
Good morning.
Good morning, Your Honor. Chad Zipfel on behalf of Knight Capital Funding, LLC.
Good morning.
Your Honor, Dylan Gould from Mark Midstock and DeMarco on behalf of Appellee Eincap, Inc.
Are you going to be arguing third or fourth?
They'll be going forth.
Fourth, okay.
Full carriage on behalf of 4 of the appellees, and I'll be arguing
Third, thank you.
Jared Lefevre on behalf of the Bay Point appellees, I may not argue, but I'm else.
You may not argue?
Yes.
Okay,
I'm last on the list.
all righty. I have one more on the list. I have James Brockman.
Right, Your Honor. We have a Queen's Funding, I won't be arguing either.
You won't be arguing.
Right, we divided.
Okay, understood. So you're definitely not arguing?
Definitely.
Definitely, okay. I'm going to change as needed to NO. Okay,
Somebody challenges.
all righty. All righty, understood. Thank you. All right, counsel, whenever you're ready.
Good morning, Your Honors. William Fecker, and I represent Harold and Faye Sosna, the appellants in this matter. I'd like to reserve 5 minutes for rebuttal.
All right.
For this court to affirm the trial court, this court must conclude that the equitable right of redemption no longer exists in Ohio. And this would be the first court, including the Ohio Supreme Court, to reach such a decision. A lot of briefing has involved the case City Mortgage versus Rosnowski, but in that case does not mention the equitable right of redemption and primarily dealt with the amounts which were to be incurred during the confirmation process as discussed in paragraph 20 of that decision.
Let me ask you a threshold question. You're claiming that there's not adequate knowledge of what is owed to exercise the equitable right of redemption. And like, do you have to proffer at any point that like, hey, we've got these assets, or we're willing to pay the undisputed amount or something like that? I mean, otherwise it seems like a get out of jail free card.
There is no there's no requirement to exercise the equitable right of redemption that the person established that they have the ability to make that payment prior to the equitable right of redemption existing. There is no such requirement whatsoever.
Well, no, I mean, it exists,
It does.
and the question is, do you have to show that you can pay something to be able to continue to avail yourself and to make these arguments on appeal?
No,
And why not?
because the equitable right of redemption is a requirement that's set forth in a court order that says to equitably redeem the property, you must pay a specific amount in 3 days. It doesn't say, let us know if you can't pay approximately this amount, and if you let us know you can approximately pay this amount, we will then tell you what the amount is to pay. That is a whole nother step that's never been discussed or set forth in any judicial decision. It is
But I
all-
guess I'm thinking about it from like almost like a harmless error standpoint, that typically, you know, if there is a mistake in something the trial court does, we have to look and see like, well, was that mistake prejudicial and ultimately sufficient to warrant reversal? So are you saying there is no such concept in the equitable right of redemption, or is it different?
There is no concept in the equitable right of redemption. The equitable right of redemption has been recognized in Ohio to pay the amount as determined by the court. It doesn't say, and you then have, because again, in this case, we don't know what the amount is. And I know in this case, the numbers are very large. It's over a $4 million amount owed. But this court has to also concern itself with somebody who may owe $60,000 on a mortgage and may be scrambling between the date when the motion for summary judgment is filed and the judgment entry is going to be entered to come up with enough funds to pay that equitable right of redemption so they can avoid the costs incurred that follow the entry of the judgment, additional bank fees, costs of sale, and the like. And again, in this case, the trial court says within 3 days, you have to pay the amount found to be due Fifth Third Bank as determined at confirmation. And confirmation comes up after the sale. So the trial court decision made it impossible for the appellants to pay the equitable right of redemption, and in every
So
case.
what happens if we agree with you? So we agree with you and we say, okay, we reverse, we send it back. What happens?
The trial court will say, okay, how much is owed in fees and expenses as of the judgment date, or as of a specific date,
Right.
when they file for motion for summary judgment, to allow us to challenge those amounts, so that when we get to a judgment.
Wait, why are you challenging it? You're saying I get to know what the amount is so I can pay it.
Well, but also to challenge it. The Fifth Third Bank simply can't say that you owe us X dollars in bank fees, Y dollars in insurance premiums, Z dollars in real estate taxes and assessments, without us saying, well, we have a right to challenge, were those expenses incurred in connection with this property or somebody else? I mean, Fifth Third Bank is not a judicial officer. Merely because Fifth Third Bank says we have advanced this much money in expenses does not make that fact true. And so they would say, and they have the information, we advanced this much money in real estate taxes, this much money in insurance, this much money in property preservation. And we could say, well, where's the proof of that? Show how it's connected to this property. Allow us to challenge it. And the court, just like the court does with a regular motion for summary judgment, when they're talking about principal and interest, we're allowed to challenge principal, you've missed a payment, you've calculated incorrect interest amount. We're allowed to challenge that in a motion for summary
But
judgment.
I guess I don't understand. I mean, you're in litigation, you've got the right of discovery. Like, how can you stand here and say, like, we have no idea what the amount is?
We did engage in discovery.
Okay.
We requested this information.
All right.
And there was,
And there's no assignment of error about like shenanigans in discovery.
because they did not seek those amounts in their motion for summary judgment. Their motion for summary judgment does not say, through this specific date, we incurred X dollars for real estate taxes, Y dollars for insurance. They simply said we're owed principal and interest that's calculable, and other fees, costs, and expenses to be incurred hereafter. And so that's what we are challenging. We understand, and this is the argument that they will make, well, if you do this to us, we will never know how much is owed because those fees continue to be incurred. And that's what Wisnowski sort of addressed. But Wisnowski, again, addressed those expenses in a confirmation process. The court in Wisnowski says, if you believe those amounts are incorrect, you can challenge them at confirmation. But Wisnowski didn't talk about the equitable right of redemption. So Fifth Third Bank could have said, and we're owed X dollars as of this date. And the court could have
Thank you,
ordered.
counsel. Give me a second. Did you have anything further?
No.
All right, thank you. You have 5 minutes you reserved?
Yes.
Oh, you know what? Right, go ahead.
But you'll have to tell me
This
when
is
I'm
my
getting-
second time with this timer, so forgive me.
Okay, you'll have to let me know when we're getting close to the end. And
This might help you, you never know.
so, again, Wisnowski, we're allowed to challenge these amounts. Fifth Third Bank is not the judicial officer. Fifth Third Bank simply says, well, here is our account records. It shows that we've advanced these expenses. We're allowed to challenge that.
But I guess what I hear you saying is, if we agreed with you and we remanded it, it's not 3 days and then the case is over. It's a prelude to a whole nother round of litigation challenging various amounts. And my question is, like, does your client have money to put up to pay the judgment?
Well, again, that's not a requirement. And as I said earlier,
Well, but then, like, what's the point of the litigation if the client doesn't have the money to effectuate the redemption?
again, we are requesting a precedent to be set. In this case, as I said, it's a very large dollar amount. But what about the homeowner who owes $50,000 and is scrambling to come up with the amount necessary?
I understand that,
to
but that's
redeem
not
the
this
property.
case. Like, what I'm worried about is this case right now.
Well, but you're also worried about established precedent. So the right of redemption applies to homeowners that owe $4 million, just like it applies to homeowners who owe $50,000. And there is no distinction. You cannot say that a homeowner that owes a lot of money that the trial court may believe, oh, they'll never come up with it, and speculate as to that. Therefore, I don't have to go through this process. Whereas the homeowner who the trial court determines, well, they may come up with this money, so I'm going to require the bank to do this. How are attorneys supposed to advise our clients what you have to show in a motion for summary judgment, unless you're going to say, as part of a motion for summary judgment to oppose it, if you want to exercise the equitable right of redemption, you have to establish that you have the ability to do so. And it's not our burden to prove anything in a motion for summary judgment other than an affirmative defense, which we're not talking about. Fifth Third Bank has acknowledged that one of the requirements is to prove the amount due. And in this case, our position is they did not establish, as of any specific date, the amount due. And if you're going to impose all these requirements to exercise the equitable right of redemption, we're changing it entirely. The case law is clear. To exercise the equitable right of redemption, you have to pay within 3 days of the date of the judgment the amount found to be due. And in this case, when you take a look at the trial court entry, you cannot do that. You cannot look at this judgment entry and say, Fifth Third Bank, if the Sosins pay X dollars, a specific amount to Fifth Third Bank, they will have exercised their equitable right of redemption, because again, the equitable right of redemption, the judgment entry says, you have to pay within 3 days the amounts which we're going to prove to be due at the confirmation. How can anybody do that, whether you owe $4 million or you owe $50,000?
Well, let me ask you this. What steps has your client taken to redeem this property, if any?
We have not, because we were only given 3 days to exercise the equitable
Well,
right.
this thing's been going on for quite some time. It's been my experience that if you really want to redeem a property, you do it before it goes into foreclosure.
Well, we did ask a discovery for these amounts to be proven to be true.
And they
We
gave
asked
it
for
to
that
you. They
information.
gave you the discovery, right?
But when they went forward with the motion for summary judgment, they did not include it, and that was was going to be our opportunity to challenge
Did you
it.
ask then what it was after the summary
Yes.
judgment?
Our entire argument before the trial court, before the magistrate and trial court, is we don't know what the equitable right of redemption is. And Fifth Third Bank says, well, you can rely
Well,
upon
I'm
our
not talking
payoff
about
letter.
that. I'm just talking about redeeming. I mean, you get all that, you get an opportunity to redeem throughout this litigation. And has your client ever made an offer to redeem the property?
I disagree, Your Honor. We had the opportunity to pay Fifth Third Bank what Fifth Third Bank said we needed to pay to avoid the continuation of the foreclosure. That's different from a party exercising its equitable right of redemption, which is a judicial process and requires a judicial determination as to the amounts owed. And there was no determination in this case as to the amounts owed. So yes, we could have said, approach Fifth Third Bank, but if Fifth Third Bank had said, well, we want you to pay X dollars, and we say, well, we don't think we owe X dollars, we think we owe Y, and the Fifth Third Bank says, we don't care what you think, we're saying you owe X, so if you want to stop us, pay what we want.
Well, let me follow up on Judge Bergeron's question. If we were to reverse this case and send it back, it seems to me it would be an endless loop, and the case would never resolve because there would always be a change as to your client's the payment on the equitable right of redemption, because that interest doesn't stop, the taxes don't stop, the costs don't stop. Do you understand what I'm saying? So it's, then you could appeal it again, and we say, oh, it has to go back because they were not apprised of their equitable right of redemption. They don't know what it
Respectfully,
is,
Your Honor.
and it would just go on forever.
Respectfully, I disagree.
Okay.
If
Well,
they had
I
said,
disagree with you
but
there.
but
I
if they had said
disagree.
in their motion, we've incurred X dollars in real estate tax advances,
Right.
Y dollars insurance advances as of a specific date, and we want those amounts included in our judgment, and state that those amounts will continue to accrue until confirmation, we would have known and had the ability to challenge those and have a judicial resolution of those amounts as of a specific date. And so, no, I disagree. If that information is in there as to what those costs are as of a judgment date or any date approximately close to the judgment date, we would have the information necessary and we would not be here today. That's what we've argued before the magistrate and the trial court, is just tell us as of a specific date what the amounts owed are so that we can determine if we're going to exercise that equitable right of redemption. But they never did. The trial court says, no, you're not entitled to that information. Fifth Third Bank says, you can rely upon our payoff letter, which makes Fifth Third Bank A, the judicial officer, which they are not. B, the payoff letter says these amounts may change, so we can't rely upon the payoff letter. And in this case, the payoff letter was issued 1 year prior to the judgment. So I don't think any judicial order that has that degree of ambiguity would be enforceable. And that's why I disagree respectfully. They can end the process.
I just have one question.
Yes. I didn't know if you're cutting me off, if I was going to reach my 5 minutes, Ron.
I paused it. If I was to put this within the framework of a summary judgment, okay,
Correct.
would you say that Fifth Third Bank did not establish that there was a material fact at issue, or they failed to establish that they were entitled to judgment as a matter of law?
They failed to establish a factual issue, as they say in their own brief, the amount due. And they presented no evidence as to these amounts that they knew about, because we did receive that information in discovery, so they knew what it was. They chose to not present those issues for a judicial
So does
determination.
that go towards that they failed to establish that they were entitled to judgment as a matter of law?
Factually, yes. They did not establish all the elements to be entitled to judgment as a matter of law.
All right. And I'll reserve the remainder of your time.
I might finish, Your Honor. All right, thank you.
Good morning.
Good morning.
May I proceed? Okay, thank you. First of all, I agree with my colleague that the law on this is clear, but I do not agree with my colleague on what that law is. The equitable right of redemption may be exercised at any time up to the entry of the judgment, and courts generally give a 3-day grace period thereafter. So the equitable right...
And let me ask about that, because I've
Yes.
seen language in the cases that say courts generally allow that,
Yes.
which is bizarre as I think about a legal rule that it should be either required or not required. Why does it say generally?
I don't know why it says generally, Your Honor. All I know is that that is the general rule, that's in the case law.
But does a
and that's what
court
happened
have
in
to
this
do
case.
it then?
I don't believe that it has to do it, because the cases say that the right ends when the judgment is entered. And so you've got this squishy kind of rule over here, not rule, but a squishy observation that courts can do this if they want to, and it did here. So not only did the Sosnas have until the entry of the judgment to exercise their equitable right of redemption, they had a 3-day grace period. The amounts that are necessary to be paid to equitably redeem are not listed in the judgment. What they are is the debt, the interest, and the court costs. And that's something that comes from the mortgagee, and that is something that came from the mortgagee in this case. Contrary to what my colleague argued, first of all, the issue on appeal is not that summary judgment was granted to Fifth Third mistakenly, or that there was a genuine issue of material fact. That's not on appeal. The issue on appeal is that The judgment is allegedly not final because it didn't include all of the amounts owed to the mortgagor. Or to
And does
the
it,
mortgagee,
and,
excuse
I
me.
mean, the only amount that I see, I'm looking at the judgment entry, is the 3.7 and change million. And then there's, interest at the rate of 4.5% from May 1st. But then there's all these other charges that aren't itemized, and there doesn't appear to be like an objective way to discern them. And I feel like that's probably what he's ultimately complaining about.
I understand what he's complaining about, and that is directly contrary to the Rosnowski, I hope I'm saying that right, the Rosnowski opinion, where the Supreme Court looked at the Fifth and Seventh Circuit decisions that were in conflict and said, yes, there may be some amounts that are still owed that are not determined as of the time of the judgment. Those may be escrow amounts and that sort of thing. And the judgment is final even though it doesn't include those specific amounts. The judgment only, to be final, has to determine the rights between each of the lien holders, which this judgment did, and it has to state the principal and the interest, which this judgment did, and it has to state that there may be other amounts that accrue before the date of the sale. And
So then I'm his client. I come and I'm like, I've got this bag of money to pay off what I think is the calculation, and I hand that bag over to you, and then you say, well, this isn't adequate because it conflicts with my calculation. So how does that get sorted out?
well, first of all, that didn't happen. in
Well,
this
I know.
case.
I understand. It's a hypothetical.
Respectfully. But the way that gets sorted out is that just like any of us in this room that have a mortgage, if we want to pay off that loan, we get those figures from the mortgage company. And contrary to what my colleague argued here, Fifth Third did include those figures in the affidavit supporting the motion for summary judgment. If you look back at the affidavit, there are statements and a loan history that shows the amount of the escrow, the amount of the interest. So those figures were there. The Sosnas filed a response to the motion for summary judgment, but they did not file an affidavit to support their own arguments. And that issue is not on appeal, that Fifth Third did not prove up its motion for summary judgment. The only issue on appeal is whether this judgment is final, which it is under the Rosnowski opinion. And the other issue is whether this court is going to get rid of the equitable right of redemption if it affirms the lower court, which is contrary to the law. I would like to point out that the Sosnas still have a statutory right of redemption. So their equitable right of redemption is gone. They could have exercised that at any time up until the judgment was entered plus 3 days by getting the payoff figures from Fifth Third, tendering those, and being done. They didn't do that. Now that the judgment is entered, they have a statutory right of redemption up until confirmation of the sale. And if they want to do that, they still can get the payoff quote. They find out the sale fees and costs. They tender that to the bank. We're done. So the arguments that the Sosnas are making are contrary to law, City Mortgage versus Rosnowski. They're contrary to well-established precedent of the equitable right of redemption and the lower court should.
And going back to my question
Yes.
that I asked Mr. Fechner, is there any obligation for a party that's in his client's position to establish an ability or willingness to effectuate the redemption to preserve that issue? In other words, and maybe there's not, I just was curious about that.
I don't know that there is a legal obligation for him to do that. But this is an equitable right of redemption. If you're going to argue that your equitable right has been stripped, then you better take some action to get the payoff, to make the payment, to get out of foreclosure. You can't come into court and say, well, Fifth Third didn't prove its figures, when it actually did. There was no money tendered from the Sosnas. What is Fifth Third supposed to do in that situation? Fifth Third has done everything it's supposed to do. It proved its case in the trial court. The judgment is final. The Sosnas have never sought to tender any money. This is this appears to be just trying to push out the sale, wasting time, incurring more fees, and then blaming it on Fifth Third,
This is what
contrary
I
to the
find
law.
interesting about the argument, because the argument is that there was a lack of opportunity to exercise the right of redemption, but that argument is tied to arguing that there was ambiguity as to the amount of damages. So then I get it back then to the summary judgment. So then is it that the amount of damages is not a necessary element?
The
Is
amount of, I'm sorry.
You understand what I'm saying?
I do understand what you're saying, but they're separate issues. For Fifth Third to get a foreclosure judgment, one of the elements it has to show is the amount of damages. It did show that in its affidavit. It showed the principal, the interest, and attached to the affidavit
Which
were
is then
statements
part
which-
of the summary judgment proceedings,
Exactly.
right? So if it's part of the summary judgment proceedings, and it's a necessary element for the summary judgment, right? Then how can it also sit outside of the summary judgment and go towards finality?
I'm sorry, how can the equitable right of redemption
No,
be?
the amount of damages, because the equitable right of redemption, the argument is tied to an ambiguity of the amount of damages.
Two things. First, there's already a Supreme Court ruling that even though the judgment doesn't include some of the damages that may accrue after the entry of the judgment, it's still a final judgment. Second, the equitable right of redemption is not tied to the judgment except for the timing of the judgment, because it cuts off the equitable right of redemption. So at any time, they could have exercised the equitable right of redemption.
It's really a question I need to ask the appellant,
I think so.
to be honest with you. I may have caused confusion by asking you the question.
I'm not sure how much more time I have, but I did want to hit on a couple of things. My colleague claimed that Fifth Third is not the judiciary. That just goes back to, it doesn't have to be a judiciary. It is the mortgagee. It is the bank that the Sosnas owe money to. And I will say that Harold Sosna has a Chapter 7 bankruptcy discharge, so I'm not arguing that he personally owes the money at this point. But it doesn't have to be the judiciary. It is the bank. It has the figures that are necessary to pay the loan in full. So the Sosnas could have obtained those figures from them, and it doesn't have to be the judiciary. I do also want to clarify that they claimed in their reply brief to exercise the equitable right of redemption, the Sosnas had to pay the amount found by the court to be due as set forth in the magistrate's decision. And in support, they cite Houseman versus City of Dayton and Aurora Bank versus Gordon. But neither of those cases said that. What those cases actually said is that the right of equitable redemption is exercised by paying the debt, interest, and court costs to prevent the sale of the property. The equitable right of redemption ends when the judgment is entered, and a common pleas court generally gives the borrower a 3-day grace period. If the right ends when the judgment is entered, then the amounts due do not come from the judgment. They obviously come from the mortgagee. And in Aurora, the paragraph that was cited by the Sosnas in the reply brief says, under foreclosure law, mortgagors have an equitable right of redemption, which allows the mortgagors to pay the debt, interest, and court costs to prevent the sale of the property. A homeowner's equity of redemption is cut off. I'd also like to point out that in City Mortgage versus Rosnowski, the court stated that while the mortgagors may need information regarding certain expenses advanced by the mortgagee, there is no evidence that unscrupulous mortgagees will willfully withhold the information in an attempt to prevent mortgagors from redeeming the property. So the Supreme Court is recognizing that, yes, even though a final judgment may not include all of the amounts due on the loan, it includes the principal, it includes the interest, and then the mortgagors are going to have to get the rest of the figures from the mortgage company. That's something that the Supreme Court of Ohio has already recognized. And I think that that's all that I have, unless you have further questions of me.
Thank you.
Okay, thank you so much.
Judge Winkler, I believe you asked why, or somebody asked, one of the judges, so I apologize, why do you have 3 days? Why is this in there? And I believe it's so that you can have, you know what the amount is, you got close to it, you got 3 days to pay it, because again, we're talking about removing a home from a property owner, which is a very drastic remedy. In Trumbull versus Ricard, the court talked about the amount found to be due by the court. And in this case, the court says, to exercise their equitable right of redemption, the Sosnas were ordered to fully pay within 3 days the sums found to be due defendant Fifth Third Bank. As the judge indicated, in that entry, it says the court further finds that there is due on the note all late charges imposed under the note, all advances made for the payment of real estate taxes and assessments, property preservation, and insurance premiums, and all costs and expenses incurred for the enforcement of the note and mortgage to be proven via confirmation of sale.
Is your client still in possession of the house?
He is.
And what about her argument that if he wanted to redeem today under the statutory right of redemption, he could do so?
The statutory right of redemption is to be exercised. You have up to 30 days after the date of the sale to exercise that. And Rosnowski actually addressed Judge Winkler's question, and I'm going to get to yours in a moment, about that we all have a never-ending opportunity because those fees and expenses are always incurred. So Rosnowski said, if those amounts that are incurred after confirmation of sale, you don't have to prove them to proceed with the sale. And to get to your question, we can challenge those questions or those amounts through the confirmation process. But at that point in time, we're paying additional fees and expenses owed to the bank, and the cost of the sale itself now become our burden.
Well, but answer my question. Could you or could you not, if your client had the means, effectuate the statutory right of redemption today?
Could not.
Why not?
Because we don't have a judicial determination as to what those amounts are. In the statutory right of redemption.
You can't call them and say, hey, what's the payoff amount?
Again, Fifth Third Bank is not the judiciary.
I understand that. But like, it's a source of information. If they told you an amount and you said, oh, that's preposterous, that's not the amount, then you could try to sort that out.
Well, when we talk about unscrupulous mortgagees, this case dealt with an unscrupulous mortgagee. In the court real estate case happened a number of years ago, where they said in the judgment, they told the property owner.
I guess what I'm getting at is, you're saying you need the equitable right of redemption, and the reason for that is to avoid people getting kicked out of their house. Your guy's still in the house, could avail himself of the statutory right of redemption, and if there is a dispute over the amount, you all can litigate that. And so again, like, my question is, what would a remand accomplish other than a right that he already has?
It's a different right recognized under Ohio law, and Fifth Third Bank.
But both rights allow you to pay off the amount.
Correct. And in Fifth Third Bank, you're pushing the burden upon us to exercise a right, where Fifth Third Bank, if they had said in their motion for summary judgment, we want these specific amounts awarded, we would not be here. They made the choice to not include in their request for a judgment the amounts that were owed as of that date for real estate taxes.
Well, then why don't you dispute the summary judgment and say, like, they haven't carried their burden on the amount of damages?
We did.
And you're not appealing that?
We're appealing that the court entered an order which did not give us the equitable right of redemption, did not specify what that amount is.
But you're not appealing the amount of damages awarded by the court in its entry.
We are appealing the fact that the trial court entry does not specify the amount necessary to be paid to exercise the equitable right of redemption.
Okay.
And I'm just reviewing my notes. And you know,
Did you understand the question that I asked Appellee?
I would appreciate
that I
it if
sort
you-
of withdrew.
I would appreciate if you would ask it again. I apologize.
Okay.
I want to make sure I answer it correctly.
And it's intertwined with the last statement made by Judge Bergeron. Your argument, as I understand it, is that your client did not have a meaningful opportunity to exercise the right of redemption. That argument is rooted and tied to what you're stating is uncertainty as to the amount of damages. Am I on track so
Correct.
far?
Correct.
Okay. So with regard to summary judgment, for example, there are some circumstances that attorney's fees can live on past summary judgment. They're very narrow, okay?
Correct.
But here we're talking about damages, all right?
Correct.
So,
I'm going to interrupt. We're talking damages in the sense that as of a date certain, this is how much Fifth Third Bank is owed in its entirety.
okay, so summary judgment was had,
Correct.
right? You're not appealing summary judgment, right?
We're,
So if the damages, if there was a flaw with the damages, that likely goes to maybe not entitled to judgment as a matter of law, or if you had contested damages, then maybe it's a material issue of fact, but, that's not what's in front of us. So I'm trying to understand how damages is living separate outside of the summary judgment, and how it becomes an issue of finality.
Our first issue on appeal is the trial court erred in entered a judgment entry which did not quantify all amounts owed as of the entry of the judgment. To me, we are challenging the grant of a judgment where the damages were incomplete. We're not arguing because we did not see they never requested this, that they said $2,000 was owed for property preservation, and we believe the number should have been $1,000 because that was never part of their request to the trial court. Their request to trial court was, the note is in default, we are owed money, and we're entitled to proceed with foreclosure, and we raised all of these arguments before the magistrate and the trial court, and were rejected, and that's why we're here, is to have this court determine, is this judgment entry that was entered by the trial court, does it still maintain and preserve the equitable right of redemption? And it does not. Or this court can say, we are going to say that the equitable right of redemption no longer exists under Ohio law for whatever reason, either because we don't believe people will want to pay it, or if they want to pay it, they could have contacted the bank in advance and made the bank the determination of how much has to be paid to keep my property to avoid these other expenses.
Or superfluous of the statutory right.
But the courts are clear, it's a dual right, number one, and number two, at the confirmation stage, I'm now paying for it to redeem the property. I'm paying increased court costs. I'm paying increased sheriff's fees. I may have to pay interest if a third party purchases it and they get interest on their deposit. I may have to pay that as part of the redemption process. So it is an important right to maintain in Ohio. It has been maintained in Ohio and should remain in Ohio, but you have to give Ohio residents and citizens a method to exercise that right where they're not relying upon a bank. I read the language in Rosnowski where the Supreme Court said that, but they also said, and if you disagree, you can extend the confirmation process, you can challenge all of those amounts, because you have 30 days to do that following the sale. The equitable right of redemption either has to be exercised prior to judgment. I agree that it does cut off at the time of foreclosure, but then there's a 3-day grace period. And in this case, we have the 3-day grace period. So there's not enough time for me to exchange information, which I tried to get from plaintiff's counsel, Fifth Third Bank. And they gave it in discovery, but did not request these amounts in their judgment. I can see that my time is up, so unless there's any
All
further
right,
questions.
thank you. Thank you for your arguments this morning.
Thank you very
We'll take the
much.
matter under submission and issue a timely decision.
Thank you.
Wish you both a wonderful afternoon.
Thank you.
All right, thank you. Talker versus Rumke. You can approach the podium. Mhm. How are you doing?
How are you?
Good, good. How much time would you like to reserve?
We'll do the 10 and 5.
Okay. Whenever
Reserve
you're ready,
5.
you can start.
Ready?
Whenever you're ready.
Okay. So, the trial court decided this issue as a matter of law. And in quoting the trial court, it decided the issue on experts, stating, Mr. Lester's expert conclusion that the tree presented a known hazard to any lay person. The trial court held that the evidence before this court is such that this aspect of the opinion of the plaintiff's expert in light of overwhelming evidence to the contrary does not create a genuine issue of material fact.
So I think your argument might be that the trial court may have weighed the evidence.
That's my entire argument.
Okay.
And while I got 10 minutes here, I don't think I need it.
Let me ask you this, Mr. Achani. What about the rural versus urban argument? Because somebody, and it may have been you, attached like Google Maps photographs to the motions for summary judgment. And when I look at those, I see a forest, and I see what appears to be a road running its way through this forest. Are you still arguing that that is urban, an urban area?
I would argue it's an issue of fact. I raised both issues on appeal, that the case, the judge decided that this was a rural area as a matter of law, and that also there was no evidence.
But if you look at those photographs, and there's nothing there except a forest and a road, and there's maybe a house off to the right, you're saying that's insufficient to determine that that's a rural area?
Yeah, Google aerial images were insufficient to determine that area.
Well, I think what I'm struggling with, to follow up on Judge Winkler's question, is like, what is the standard to determine urban versus rural? Because it almost sounds like I know it when you see it inquiry, and I don't see a whole lot of guidance in the Supreme Court's decision, Heckert, on how we're supposed to do that. And I look at both of your submissions at summary judgment, and they're like, this is clearly rural, you're like, this is clearly urban, but where's, like, there's no facts really adduced there on either side. So, like, what's the standard? How are we supposed to figure that out?
And forgive me, I was really going to address urban versus rural on rebuttal, but I'll address it now.
Well,
I think that
I'm interested in it right now.
my primary argument was, regardless of whether this is rural or urban, it's an issue of notice. It's always an issue of notice that predicates whether or not you've exercised reasonable care in the situation. And notice comes down to actual constructive. But I'll try and address your issue.
The notice goes to the duty.
Notice goes to duty,
right.
Sure. And I think I've read through all the cases. I've not seen an exhaustive list of factors to say this area is urban or rural. I think that it is a list of factors to make that issue.
Yeah, but what are those factors? Because I'm even having a hard time figuring that out.
I mean, there's the rationale cited in Heckert, because there's not a whole lot of dispute on the law. We've all cited the same law here, and we all go back to Heckert, 1984 Supreme Court decision, which cites Hay further, which cites the second jurisprudence, which, the rationale for the distinction between the duty, rural versus urban, the rule of non-liability for natural conditions was obviously a practical necessity in the earlier days, when the land was largely in a primitive state. It remains a considerable extent necessary in rural communities where the burden of inspecting and improving land is likely to be entirely disproportionate, not only to any threatened harm, but to the value of the land itself. But it is scarcely suited to cities to say that a landowner may escape all liability for serious damage to his neighbors merely by allowing nature to take its course. That's the rationale behind whether or not we're going to distinguish a duty for a rural owner versus an urban
Let
owner.
me ask you this then. Say I want to go for a Sunday drive down Buell Road and pack everybody into the car. And we're driving through, and I say, hey, look, kids, we're in the middle of 340 acres. There's 48,000 trees here, and this road goes to nowhere. Well, I mean, that's in evidence through deposition or otherwise, right? So, I mean, and I'm just saying, it seems to me that based on those facts and other facts that were presented, that somebody could make that determination. And you don't have to weigh it.
They could.
You know, you could be on Colruyt Avenue and say, wow, look, look at all these stores. You know, this looks kind of urban to me. And then you go on to Buell Road and you're in the middle of a forest. And do you understand what I'm saying? It seems to me that it's
And Buell
it's
Road
not
eventually
something
ends up
that's in
Butler County.
dispute, I guess is what I'm trying to impart to you. At least in my mind, it's not in dispute.
I think that there was evidence in the record that a jury could weigh. Because eventually Buell Road goes to Butler County.
Yes.
But where this happened was not in Butler County.
Right.
Where this happened was not on a farm. It happened on Rumpke's property, a corporation within Colerain Township, within the city of Cincinnati, within Hamilton County. And, I mean, you could go on to say there's forest that goes, you know, to a certain area. And the evidence that I presented was the zoning. And the zoning
Right.
did not say that this area was,
But the zoning for that particular area, I know it was residential, R2, I think, and the purpose is to preserve the rural nature of Colerain Township. So does that, can we say, well, the trustees want to preserve the rural nature by zoning it this way, so it's obviously rural?
some areas of Colerain Township are in like rural.
Well, with the zoning there, it says to preserve the rural nature of, I believe that's what it said.
Well, I guess that gets to my question, like what you just said, like some areas are urban, some areas are rural. Like, how do we're in an urban county, like how do we draw the dividing line between rural and urban? Is it street by street? Is it neighborhood by neighborhood? Like, how do we make that determination?
You don't. It's a heavy burden to do that. Where does it start and where does it stop? Leave it to the jury. If there's evidence in the record, let the jury weigh the evidence.
Well, but what's the jury supposed to weigh at the end of the day? How do you instruct the jury here?
I think that there's a case that doesn't say the exhaustive list of factors, but there are factors to consider.
Okay.
I understand your argument on urban versus rural because it does feel like it's an issue of fact. Is there any case that actually has said that it is an issue of fact versus an issue of law? Because it is a threshold that has to be determined before you get to the duty.
Sure, I don't know that any case has outright said this is an issue of fact, other than the case cited, I believe by Heckard. I'd have to pull back up and maybe I'll do so on rebuttal, that says a jury can consider these factors.
I mean, Heckard seemed to treat it as an issue of law, okay? But I also understand your second argument is that, inconsequential to whether it's rural or urban. Your second argument is that that there was material issues of fact with regard to the duty itself.
I do. So I think I'm happy to continue to discuss the rural versus urban. I think it's a red herring because, again, we're back to notice, and we're back to it's actual or constructive, and there was no evidence of actual, so what is the constructive notice? But I started out quoting the opinion from the trial court because they addressed Gregory Lester opined this, but the evidence overwhelmingly to the contrary does not create a genuine admission of material fact. What is that evidence that is overwhelmingly to the contrary? I don't think you can then go and list that because then it's an admission. We're weighing the evidence here. We're taking this. But if the opinion does cite the entry from the trial court does cite that.
I mean, I'm sure it was the other side's expert.
Yeah, the other side's expert. As simple as that statement. Defendant Appellee's expert disagrees. But we can't get into the weeds of that. What do you disagree about? That's in the province of the jury, which is my main argument. And I think that as it stands, what are we looking to do with Heckard? Expand that? What can I do to get in front of a jury? What more could I have done as far as the evidence?
I mean, when I looked at everything, it almost even though the trial court doesn't say it, it almost feels to a certain extent as if, so the expert for the defendant makes a statement to sort of disqualify the determination of your expert by saying that the wrong tree was analyzed. So it almost felt as if the trial court may have made a judgment on that.
I couldn't say. We did discuss that, but there was no real opinion on that issue. And again, what you're competing experts. Anytime you take that, and then appellant's expert rebutted that with an affidavit in summary judgment. So again, that's in, I'm at past 10 minutes. Happy to answer any more questions on that.
Thank you.
I'll save for
All right,
rebuttal.
thank you.
Thank you.
Good morning.
Good morning, Your Honors. May it please the court. We'll get right into rural versus urban, and then we'll go on tackle issue 2. There are factors laid out by both the Hecker Court and Kenny Court in the 7th District. Some of those factors include the location of the highway, right? The size and type, how many people are frequenting it. If you
Which
look
I didn't see evidence of in the record in terms of like what is the traffic that goes down that road on a daily basis. And like,
I requested that in discovery, and Coleraine Township doesn't have a traffic count on Buell
but I mean,
Road.
like, what would that do at the end of the day? Like, if
No,
it's
you're
if it's 18 cars versus 180 cars, like, how do I evaluate that? Trying to decide this as a matter of law, or is that even possible?
Well, I think the Kenny Court also has some instructive factors, right? They look at there's densely forested trees on both sides of the road, just like Buell Road. There was the closest structure in the Kenny case was more than 187 feet away from the point of the accident. In this case, the nearest house is more than 1,000 feet away, 3 football fields away. So I mean, we're talking about there are no facts actually that establish that this is urban, right? All the facts established in the evidence show that this is a rural area. In fact, Mr. Talkert sat there in his truck with the tree on top of him for more than 30 minutes before another car came on that road. If that doesn't establish that this is a rural area that no one travels, I don't know what else does.
Yeah, but I mean, like, we are in an urban county.
Yes.
And like, I was up on the west side recently, and I'm like driving through Mount Airy Forest, and you feel like you're in the middle of nowhere. But then you pop out and you're on Coleraine Avenue, and you're definitely in the middle of somewhere there. So like, how do we calibrate that? Is it a neighborhood by neighborhood? Is it how?
It's specific to the actual area of the accident where the tree fell, right? You have to go to the location of where the accident occurred. If the location happened in Mount Airy Forest, then it would be a rural area, right? Those are hundreds or thousands of acres of a forested area, right? If it happens on Coleraine Avenue in Mount Airy,
That's what makes this very interesting, because when you read the case law, it's talking about a highway. It refers to the road as a highway, right?
Yes.
So it gives you the impression that we're talking about,
long
that
streets.
highway, right?
Yeah.
But then when you start looking at the test, it feels more like you're piecing it, So which piece are you at? And so it's not that even though it seems to define the highway, it's not really defining the highway. It's defining a segment of the highway.
Sure.
Do you understand what I'm saying?
Yes, it's identifying the area where the accident
Yes.
occurred.
So it's
right?
very interesting.
Yes.
The broad language and then the specific test.
But to
are
Judge
not
Bergeron's
necessarily consistent.
Yeah, to his point, or to Judge Bergeron's point earlier, is like, what would you send back to the jury? Like, there was no way you could send this back as both to a jury and say, is it rural or is it urban, right? It's a matter of law. The judge is going to send back one set of instructions saying, under this standard, this is a rural land. You have to find whether or not Rumpke had actual or constructive notice of a defect in the tree. Or if it's urban, the judge finds it's urban land, he's going to send back an instruction and say, did Rumpke meet its duty to inspect all the trees on its property?
But getting back to my point about how you prove this as a matter of law, like, I didn't see any expert opinion from either side on the urban versus rural distinction. And is it just to know it when you see it? I mean, your guy had an affidavit, but I didn't take him as an expert. He was just like, hey, I'm employed by Rumpke, and here's where this is.
Oh, but Mr. Weber also included in his expert reporting that was provided in his affidavit or subsumed in his
Well,
affidavit.
but he's a tree guy. He's not an expert on urban versus rural, right?
Well, no, I mean, he's an arborist that testifies across the country in wrongful death cases. This guy has certainly analyzed whether or not trees fall into urban or rural areas, and he identified and quantified how many trees were within the area, right? He quantified and said 320 acres, 48,000 trees. He looked at Ohio Department of Agriculture, U.S. Department of Agriculture study on U.S. trees to figure out and quantify how many trees were in the area, and that's how he came up with 48,000 trees. So, I mean, there is expert testimony that talks about rural characteristics of this land. Okay.
Can we get to the duty now? Because that's the second
Yes.
argument on the issue of fact.
No, I mean, at the end of yes, we're moving on to the second issue presented, whether or not Rumpke had knowledge of a defect in the tree itself, or actual or constructive. You've already heard, plaintiff appellant saying that there's no actual knowledge or evidence of actual knowledge of Rumpke, right? Because we do these daily drive-bys for our landfill managers. We call Ritchie Tree Service. We do inspections. There were 15 inspections within the 5 years prior to this accident. So this really is a question of constructive knowledge. Look, I'm not going to say that the language used by the trial court was the best in its decision, saying that using the words overwhelming evidence. It certainly appears that he was weighing evidence. I would suggest to this court you have de novo review powers. And in this case, the evidence presented by the expert on the other side is so factually insignificant. It does not meet the mere scintilla of evidence or significant.
Well, but I read that, like, your guy seems very credentialed, you're expert.
Yes.
Their report is more bare bones,
One page, yes.
but there is an opinion in there that there is fungus that would have been visible. The tree had to have been dead for, I think it was
Said several years.
up to 10 years.
Yep.
And that it would have been apparent to anyone that would have seen that.
But his opinion's based on the stump in the woods, right? And so the stump in the woods was identified not by Mr. Lester, but it was identified by a representative of Connor and Chani Levy, right? They show up 11 months after the accident. Mr. Lester shows up to the scene, and Ian Cummings says, that's the stump right there from the tree that fell on Mr. Tackert's vehicle. Mr. Lester's opinions are not scientifically reliable, right? I mean, he does no canvas of the hillside. He has no photographs of the tree that was on Mr. Tackert's vehicle that day to compare it to. He takes no measurements. He takes no photographs. If he had actually read the police report, which he hadn't, because when I deposed him, he admitted he had never seen the police report before. The police report says that the trees, inappropriately says, the radius is 63 inches. Obviously, they meant circumference is 63 inches, because that means the diameter is 20.05, right? And so if you look at the segments, and this is in the evidence in the record, if you look at the segments of the tree on the roadway, there's a 12-foot section here on the roadway and an 18-foot section on Mr. Tackert's vehicle, right? So we're talking about a tree that's measured 20 inches around, 20 inches in diameter, 30 feet in the sky. The stump that they identify was only 15 to 16 inches in diameter. I'm not sure of a tree that exists that goes from 15 or 16 inches at 6 feet high and 30 feet high in the air somehow becomes 20 inches in diameter, right? It's so scientifically and mathematically implausible.
If that's the case, then did you move to strike the expert?
We did move to strike the expert, yes.
Okay.
And there is an opinion
And that
from...
was denied, was it not?
It was denied, but if you read the decision, he's saying, look, Mr. Lester has been an arborist for 60-plus years, right? He's an arborist. He's qualified to give opinions. But if you read in between the lines, later in that same opinion, he's clearly saying whether or not these opinions they're enough here for summary judgment to get to
But
summary
doesn't that
judgment.
create an issue because you did move, it was denied, right? So then we get back to was the trial court weighing the evidence?
And I think in a de novo review, Your Honors, you can look and see the same thing that Judge Dinklager saw below, right? The evidence here does not meet significant probative value. It does not meet the mere scintilla of evidence. It is mere scintilla of evidence. It's not more than that, right? You need to create a genuine issue of material fact. He does, as the plaintiff, to avoid summary judgment on this issue. And Mr. Lester giving opinions about a stump in the woods, and if you read his deposition, I clarify because I asked him to look at the trunk on the car, right? Look at the trunk of the tree on Mr. Tackert's vehicle. Do you see any evidence of missing bark? No. Do you see any evidence of decay or defective condition on this tree
As I understand it, and let me
Yeah.
know if I've misunderstood, please. This wasn't a tree that fell on a vehicle. This was like a large portion or a large branch of the tree that fell.
No,
I
it's the
understood-
tree. No, it's the tree. It's a 20-inch round trunk. I mean, it's the trunk of a tree, 30 feet up. So, yeah, I can go back to it. If you want to see the photos? They're in evidence, Your Honor, but,
You're saying it was a large trunk 30 feet up.
yeah, like here, like here's a picture.
Right, but it fell from 30 feet up, right?
No, it broke. So,
But I'm trying-
yeah, look, see, there's a 12-foot section on the roadway here.
Right, but
The section here is 18
of an
feet.
ash tree.
an
Ash
ash
trees
tree.
tend to grow tall.
So minimally, there's 30.
Tall and lean, actually. They don't have lower branches.
Yeah, there's more than 30 feet of trunk in the photographs from the scene of the accident. There's also structure above that. There's a Y section of the tree that goes above that for the higher branches. What's in the woods
What was
are
the
stumps.
amount left of the tree that was standing when a portion of it fell?
We don't know because no one's ever identified the stump.
Okay, so that could
But
have been.
your guy hasn't identified the stump either?
No, there are literally, again, 48,000 trees in this area. There are dozens and dozens. This is
Well,
also
but I
very-
mean, like,
Here's
it's,
the hillside, like this.
right, I don't
We traipse
understand.
the hillside. We traipse the hillside.
And you're just
Multiple
like, we
times.
can't even figure out where this came from.
Can't
It just
identify the-
fell from the sky.
No, we believe it fell up, he believes that it fell up higher, which we never got to because of the steepness of the hillside. But the one lower that was within like 15 or 20 feet of the road, which his expert, well, actually Ian Cummings identified, was within like 15 or 20 feet of the roadway. And so that was easy to get to. The other one, like we didn't do a full canvas because it's so overgrown with honeysuckle and trees, you can't get all the way through. But you can see dozens and dozens of stumps throughout the hillside.
Right, because they're all dead ash trees.
There's a lot of dead ash trees. Well, I mean, yeah, we took down more than 100 in the 5 years prior to this incident.
Right.
And we continue to do so, right? Anything within striking distance of the road, if it looks to be defect, this is the time of year, right? Is there a dead tree, no branch structure, missing bark, take it down, right? This is the time of year to do that. But we maintain that this area is rural and that his expert did not create a genuine issue of material fact.
I
on
want
a
to
constructive
clarify one
knowledge.
more thing also.
Yes.
And you let me know if I misunderstood. My understanding is there doesn't seem to be a dispute that the defective tree or the alleged defective tree would have been visible from the road. Am I understanding that correctly?
No, because we never identified the stump, to Judge Bergeron's
Okay,
point.
so-
We've never identified, so we don't know whether or not it would have been visible from the road or not,
Okay.
right? Again, that's plaintiff's burden. All we're saying is the stump that they identified cannot be factually related to the tree that was on Mr. Tucker's vehicle. And his expert agreed, there's no evidence of decay on that vehicle. And his deposition is in evidence, it's been submitted. You can look at the record and see that he's admitted there is no evidence of decay on the outward part of that tree, on the vehicle, not the stump.
But the expert does identify fungus on the stump.
On a stump that's not related to the tree, yes.
Well, but again, doesn't that, okay. I mean,
Was that established, I guess, sorry, Judge?
Yeah, because.
Was that ever established that his expert had the wrong tree?
It was discussed at
Or
length.
you established it?
It's established not only by our experts' opinions, but also it was discussed at length in the oral argument below. We believe that is why the trial court wrote the opinion how he wrote it.
I mean, it appears to me as if that's a possibility, although it's not in the decision, and it was written quite differently. But then that brings me
Yes.
back to the motion, and that the motion was denied. So it creates some interesting things to think about.
Yes. No, I think there's that double-edged sort of a trial court saying, well, he's got 60-plus years as an arborist. He clearly is a qualified arborist. His opinion is not anywhere related to what this case is about, though, right? It's about a stump in the woods that's not related to the tree on the car. So,
All right, well, thank you.
So,
Unless
thank
there's
you.
any other questions. All right, thank you.
Thank you.
Ready? I remember the oral argument, and the judge says, I'm stumped here. what are we doing here? What is the standard of review? And what's my burden as the plaintiff? More likely than not, if I put forth evidence, this is that the jury could say more likely than not, they can decide the issue. That's the threshold.
So after your expert was cross-examined on this stump, did he adhere to his decision, to his opinion that this was indeed the stump of the tree that fell?
And I'm going to quote, yes, in opposition to them, their attempt to strike Mr. Lester as an expert, he supplied his affidavit, an affidavit in support. And during his inspection, I saw no other trunks in the area. So the standard is, and he opines, this is the tree. And I opined to that more likely than not, because I've gone to the area, I inspected it, did what I can, and I said, that's the stump. It makes sense, the location. Well, we say this is 48, whatever the numbers are, this happened in one area. And Mr. Lester went out to the area and said, that's the stump. Here's why. Here's my opinion.
And it seems like the other side isn't necessarily, that's not the stump, this is the stump.
Right.
Right? It's, we don't know what the stump is, but that's not it.
So in Mr. Weber, the appellee's expert deposition, he goes on to opine, well, every tree is in its own universe. Okay, where, and did you identify it? And he actually wrote an opinion, because this was a dismissed case. He wrote an opinion in the first filing of the case, which he then went back on, and because he identified a defect. He said the defect was visible at this point, but then in the refiling, he backed away from that opinion and said, I don't know where. I don't know where this came from, because initially he said the tree was, something happened.
I'm sorry, who's he?
Sorry, Mr. Weber. This is
Their expert.
This is appellee's expert. It catapulted in some mysterious way and then launched itself onto Mr. Talpert's vehicle. But we're battling experts here. Sure, he wrote a 20-page opinion, cited credentials. Mr. Lester's in his 70s. And he doesn't typically testify as an expert in cases, but he was qualified here. He survived the opposition to strike him, and he did render an opinion in this case, which is, this case can get complex on the facts, rural versus urban. What do we, how do we decide that issue? Are we looking to adhere to this law, which seems to have, basis and rationale going back to, I don't know how long, but it's what is the threshold of evidence to get to a jury in this case? And when you have competing experts, I think that answers the question that you should survive summary judgment and be able to try your case in front of a jury.
All right. Well, thank you for your argument this morning.
Thank you.
All right. Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision. Have a wonderful week.
Make Boston argue.
Okay, I think, are we all in
Wait, no.
place, except for a judge?
Shall we start?
You can take a seat. Just let me know when you're ready. You good? Yeah. Okay, thank you. All right, whenever you're ready.
to reserve 5 minutes for rebuttal.
All right.
May it please the court, Jonathan Ellis here on behalf of S&T Bank. The trial court's decision in this case rests on 3 fundamental and reinforcing flaws. First, the trial court misapplied Ohio's liberal notice pleading standard. Under the governing precedent from the Ohio Supreme Court, Rule 8 requires a plaintiff to put forth sufficient factual detail in their complaint to put the defendants on notice of the alleged wrongdoing. A trial court should not dismiss a complaint on a motion to dismiss unless there is no doubt that there are no set of facts consistent with that complaint could lead to liability. Although the trial court recited that standard in the background section, it held my client to a much higher one akin and even greater than the federal plausibility standard under Twombly and Iqbal, just as the defendants urged it to do. Several defendants urged this court to do the same, but as the 8th District rightly recognized in Tuleta, until the Ohio Supreme Court adopts the plausibility standard or the Ohio rules change, this court should maintain the notice pleading standard. Now, to be clear, we think we passed the plausibility standard as well, but under the proper standard, we think this complaint is clearly sufficient. Second, the trial court repeatedly refused to accept as true our allegations about the defendant's conduct, knowledge, and role in the alleged conspiracy. The defendants candidly also defend that approach in this court. In their view, any allegation that does not specifically list a defendant by name is impermissible shotgun pleading and should be ignored. But that's wrong. Shotgun pleading is the lumping together of defendants with disparate roles in a case and alleging in a collective fashion in a way that makes it unclear which of the defendants is alleged to have taken which of the acts. But that's not what we've done here. We've alleged that the, quote, defendants, unquote, knowingly provided funds that prolonged and expanded Mr. Sosna's unlawful fraud, and then knowingly accepted, or more accurately took, funds from his accounts that were the fruits of that unlawful scheme.
It
And
seems
that's
to
what
me
we
that
mean.
central to that portion is the access that was had to the account, and then the change of the terms of the monies, the acceleration of the payment period, the increase of the interest after the check kiting began.
Yeah, yes, Your Honor.
That's what I'm understanding,
I
right?
think it is a combination, yes, Your Honor,
Okay.
of the intense access that they had to Mr. Sosna's bank accounts. And
So
they
it's
could
not
see the
about direct
transactions.
evidence, it's really about sort of, in a way, circumstantial, or the circumstances and inferences that are being drawn from that.
Well, to be clear, Your Honor, we do make direct allegations. At this stage, the question isn't what our evidence is. We haven't had discovery, and we don't have to prove our case at this stage of the case. We've made direct allegations that each of the defendants had that access, that each of the defendants knew that Mr. Sosna was engaged in this check-kiting scheme.
Well, the criminality is really directed to Sosna. The fraud and so on is Sosna directly.
The fraud,
This is
yes.
all about the conspiracy. The conspiracy is then what ties it to the defendants.
That is, the conspiracy tie makes the defendants liable for Mr. Sosna's fraud. Now, the defendants themselves, we allege, have engaged in tortious interference, and that is part of the conspiracy as well. But with regard to the fraud, that's correct. But what we've alleged is that they are in a common plan, a common design to provide the funds that then extend to prolong that fraud and then to benefit, to profit from it. And we've made, again, direct allegations. Now, we've made a host of other allegations that make those allegations, those direct allegations, plausible, even though I don't think that's the right standard for this court. And those allegations do include, Your Honor, the access that they had, the scrutiny that they applied to Mr. Sosna's financial dealings and his transactions, and then the conduct, as you say, the repeated advances of funds well beyond what a rational defendant would do if they knew that Mr. Sosna had to support those with the nursing facilities that have a set number of beds that are failing. I think when you look at all that, it makes the direct allegations particularly plausible, particularly compelling here, certainly sufficient to get over the notice pleading standard and allow us to get discovery where we can actually have a chance to prove our allegations. And then the third error, Your Honor, on the district court and the trial court's decision.
Before you go on, part of the civil conspiracy, an element of it is that the conspiracy is acting in combination to injure another in a way not competent of one alone. So my question for you is, could Mr. Sosna have committed this bank fraud absent the MCAs?
He'd not have committed the bank fraud in the way that he did. This was a massive check.
I understand
scheme. And so it's possible to have a check kiting scheme, of course, without additional funding, but not one to this scale and not one of this duration. Now, I actually don't think that's like what that phrase means. If you look at the Gosden decision, I think it lays out that nicely. I understand what that phrase to mean is that there has to be an underlying tort. You can't find someone liable for civil conspiracy in a way that if they did that by themselves, it would be lawful. And so what that phrase means in the case is, and as Gosden does explain this, is it just means that there has to be some tortious act underlying the civil conspiracy. And here it's that fraud, and there's really no dispute. He was convicted felon of
Sure.
the fraud.
Is there an act independent, though? I mean, of Mr. Sosna's fraud? Is there an act that ties this conspiracy together other than the fraud?
Yes, it is the advancement of the funds by the defendants here. I think what the advancements do is allow Mr. Sosna to then continue this kite, to then go at greater and greater lengths, and then allows the defendants to know that they're going to get paid back in a way that wouldn't be rational if it were not for the underlying fraud. And I think both those things are enough to make them conspirators. I think the best decision on both the two decisions is the Williams decision from the Ohio Supreme Court and the Meehan decision from this court. The Williams decision is actually remarkably on point. It involves a civil conspiracy with a bank and a fraudster. And what the court said there is, although the banks were engaged in loans that would otherwise have been lawful, because they knew that they were providing funds that allowed the third party, their conspirator, to then execute a fraud, then they could be found to be in this common design and a conspiracy with the fraudster, and then liable for that fraud. And I think that's quite similar to what we have here. The Meehan decision goes on and adds slightly different facts, but makes clear that it's not just the providing of the funds that can put someone into a conspiracy, into a common design, but it's the accepting of the funds, knowing that those funds were obtained through tortious behavior. And we've alleged both those things have happened here with regard to the defendants. The third error that the court below committed is to treat our allegations, to understand them as alleging and attacking the MCA industry and their business model as a whole. And my friends have picked up that theme in this court. But again, that's not what we're doing here. I mean, to be sure, the MCA's common practices in this industry do give them remarkable insight into their clients' financial dealings, and there are consequences to that insight. But our allegations are not that level of insight, or that the business itself, just by carrying out their activities, is a tort. Rather, it is once you have that insight that gives you this bird's eye view into this massive check-kiting scheme, when you obtain knowledge that your client is engaged in this scheme and is paying your funds through the money that is stealing from S&T Bank and other banks, then you have an obligation when you make a decision to keep doing business with that individual and to keep providing funds that extend and prolong that scheme, and then accepting funds and profiting handsomely from it. That is the tort. And you don't have to do that to be an MCA lender, and that's what we've alleged in this case. If there are no further questions, I'll reserve my time for rebuttal.
Okay, I'll reserve the remainder of the time then.
May it please the court, Nathaniel Churd on behalf of the Addisource Appellees. With the court's permission, I would like to use 10 minutes of our time before I defer to my colleagues. Before I address the specific arguments raised by my friends on the other side, I think it's helpful to zoom out and quickly take a high-level view of what S&T is asking this court to do. According to the allegations in the complaint, Mr. Sosna did business with the MCAs for roughly 15 months. And during the second half of that 15-month
I
period...
apologize. What was it that you reserved of your 10 minutes?
I'm
Are
sorry,
you
Your-
reserving time? Never mind. Go ahead. Go ahead. Oh, this is throwing me off because it actually doesn't coincide with any of this, so it's becoming a little bit unwieldy.
According to the allegations in the complaint, Mr. Sazan did business with the MCAs for 15 months, and during the second half of that time frame, engaged in his check kiting scheme with 4 different banks, using overdraft protection that 2 or 3 of them offered to float his deficit. That's according to the allegations in the complaint. Now, of course, we know that Mr. Sazan went to jail, but there's not a single allegation, criminal or civil, that any of the MCAs engaged in any check kiting themselves or otherwise helped Mr. Sazan with his scheme. I would also add, S&T made its own business decision to honor checks that had not cleared. Now, of course, S&T is unhappy with the result of that decision, but what it has done is, with no supporting allegations, it's asked Judge Branch and now this court to support a 52 MCA conspiracy claim alleging that all the MCAs somehow, some way, were in on Mr. Sazan's scheme. Ironically, omitting the other banks who offered Mr. Sazna the overdraft protection he used to facilitate his scheme. Judge Branch got it right. Plaintiffs cannot get by with alleging speculation. And what S&T did here to hide its lack of specificity is 2 things. It offered a lot of industry-wide grievances and allegations and shotgun pleading, extrapolating random acts of 2 or 3 MCAs to all 52. And I think this point can be illustrated very quickly by looking at the 6 primary allegations that make up the complaint. Number 1, predatory practices. The complaint alleges specifically that 1 MCA has been investigated by the FTC for predatory practice. It's completely unrelated to this case, only 1. And yet, S&T goes on in at least 19 paragraphs to allege the entire industry and that all MCAs are predatory. Not only is the characterization wrong, but plaintiffs just can't get by with alleging statistics. There must be specific allegations against specific defendants. Number 2, account access or knowledge. The complaint only shows or specifically alleges that 4 MCAs had account access or knowledge, and none of those, I might add, being the Addy source appellees.
It seems to me that where your arguments part is as to what the pleadings actually say. So you're saying like, oh, it was speculative. They're saying, no, it isn't speculative. These are the things that we actually put in the pleadings that have to do with the conspiracy with regard to the MCAs. So it's very interesting because the pleadings speak for themselves.
I think the issue, though, Your Honor, is that, yes, S&T alleges that all 52 MCAs engaged in the conspiracy, but that's not enough. When you look at the specific allegations, there is nothing there to support a 52 MCA conspiracy claim. Another example, one of the big ones, threats. The specific allegations show that only 1 MCA is alleged to have made a physical threat. And I might add that MCA is no longer a party. They allege that 2 MCAs made financial threats, whatever that's supposed to mean, none of those being any of my clients. And yet, S&T goes on in at least 10 paragraphs to allege that all MCAs must have, upon information and belief, threatened Mr. Sazna in some way. Shared information or money, the specific allegations show that only 5 MCAs are specifically alleged to have shared information or money, none of those being my clients, the Addy source appellees, yet S&T goes on in at least 17 paragraphs. And this continues. The last 2, shared addresses or employees, there are specific allegations that 5 pairs of MCAs shared an address and 3 sets of MCAs shared an employee. None of those being my clients, but yet S&T goes on to allege that all the MCAs must have done that. There's one, if the court would indulge one last insight into the briefing, S&T's briefing at this court on the merits cites to the complaint 154 times for factual support. If you look up those citations, there's only 38 paragraphs to the complaint that actually name a specific MCA, and those 38 are comprised of 17 paragraphs. It is difficult to imagine any 52-party complaint of any kind that could be based off of 17 paragraphs. And that's exactly why S&T's leading argument has nothing to do with the merits. It's an attempt to contrive or manufacture an error by Judge Branch's infrequent use of the word plausible. Number one, I would just note that this pleading standard argument is irrelevant because this is de novo review. Even S&T's own case, the Sackstetter case, confirms this. In Sackstetter, the trial court expressly adopted the Twombly-Iqbal standard, expressly applied it. The second district decided that that was error because Ohio follows the pleading standard, but nonetheless said, quote, the error would not be prejudicial unless the complaint fails on the correct standard. So it's just
So
irrelevant.
what you're asking us is not to remand it for reconsideration, it's basically just to make the determination whether the pleadings pass muster.
That's exactly right.
Okay.
Yes. I would also note that the pleading standard argument is misdirection because it's non-controversial that notice pleading requires a basic level of plausibility. It cannot be that S&T can just argue at large that all MCAs everywhere are goblins conspiring to put banks out of business, and that somehow creates a claim. They must allege a specific act against specific MCAs. And it's also largely moot. Both conspiracy and fraud require a higher pleading standard, specificity and particularity, respectively.
Do you have any case law other than the Avery case saying that, Ohio-specific cases, saying that the pleading standard is higher for civil conspiracy?
The Avery case is the only case that we cited in our brief, Your Honor.
Thank you.
Finally, I would add on the notice or the pleading standard argument that it's largely theater because it's undisputed. Judge Branch cited the correct standard. It's clear she applied the correct standard. And her infrequent use of the word plausible doesn't magically create an error or mean that she decided to change the standard that she was applying. With respect to the conspiracy claim, I would just note to the court, first, there is not a single allegation against any of my clients that the anti-source appellees did any act in furtherance of it. Number two, if this court were to countenance S&T's generalized allegations regarding conspiracy, in pages 19 and 20 of S&T's brief, they cite to 4 types of allegations that they argue supports a conspiracy theory. Number 1, that they concealed their true identities, the MCAs. Number 2, that they used the same brokers. Number 3, that the MCA knew Mr. Sosna's details. And 4, that some of them shared addresses, employees, or funds. First, I would note that the first allegation of concealment of true identities only applies to one MCA, that's Avanza, who is no longer a party to this case. Number 2, I would note that much of these allegations would predate the check kiting scheme. And number 3, any reasonable inference of those remaining allegations cannot support a conspiracy claim. If using the same broker is enough, it's difficult to imagine how any limit to the frivolous claims that could be brought to the trial court or to this court just because different parties used the same real estate broker, for instance, or maybe the same insurance broker. That just cannot be enough. Any reasonable inference here is that Mr. Sosna contacted a broker asking for MCA funding, and that broker then in turn gave his information to the MCAs which contacted him. And I think one other thing I would note is that the Williams and Matthews case that S&T cites for the idea that a lender conspires with a fraudster merely by lending money to them they're simply an opposite to this. In both those cases, the lenders transacted directly with the victim. They did so fraudulently and unethically, and they did so knowing that the purpose of the loans, which were home improvement, were never going to meet their objective because the contractor was a fraudster. In fact, on the, I believe it was the Williams case, the banks had a special name for the loan because there were so many issues. They called it the Blair loan. And yet they continued to fraudulently and unethically go out and offer these loans. Those cases, there's no speculation. There was a nexus between the lender and the victim in the transactions. This case is completely in opposite. If there are no further questions for me, I would defer the rest of my time to my colleagues.
I have one question. Did I misunderstand the pleadings? Because I understood that the pleadings stated that the MCAs changed the terms of the monies after the check kiting had begun.
I think my understanding, Your Honor, of that allegation in the complaint is that the terms became shorter term. In other words, the MCAs, I think it's clear.
That's what I understood
Okay.
as in pleadings, okay.
And so I would just offer to the court that the only reasonable inference from that is that the MCAs clearly knew Mr. Sazna was not as worthy a borrower. It doesn't mean that they're not permitted to do business with him, but like any lender, the cost of lending that money is going to go up as they seek to protect their what they're lending. It doesn't mean there's no inference there that means that they knew that he was kiting checks.
But they knew that what I understand in your response is that they would have had known about the status of solvency of Mr. Sazna. That's what I understood in your response.
I think the issue there, though, is if taken to its logical end, S&T's argument there would mean that if any bank runs a credit check and discovers that the borrower has other obligations and may not be in the best financial situation, that they're at risk for either a tortious interference or some type of claim by lending that borrower money because they now know that the borrower has other obligations, and that by lending this new amount of money, it'll make it more difficult. That's just not the law in Ohio. Lenders, businesses in general, are justified in pursuing their own business interest. It's not relevant whether Mr. Sazna was in the best financial shape or in the worst financial shape. They had a right.
And I understand what you're saying, because the illegal act is not about the lending of the money, because the legal act is about the fraud which took place at the hands of Sazna. What we're trying to assess is whether there was enough at the pleadings for the civil conspiracy, because the civil conspiracy gets you to the fraud.
I think, though, that...
So it seems as if you're characterizing the illegal act, the lending of the money, and it's like, no, we potentially have the legal act within the fraud of Sazna. It's really whether there was enough pled, and we're talking about pleadings, whether there's enough pled to survive civil, with regard to civil conspiracy.
But to that point, Your Honor, the Avery case point blank says that the plaintiff must allege actual damages attributable to the conspiracy in addition to those caused by the underlying tort. As S&T has pled this complaint, that's not possible, because the only underlying tort, and they concede this in pages 23 of the brief, the only underlying tort that they argue supports a conspiracy is the fraud. And so there would be there's no set of facts here by which S&T could show damages in addition to the fraud that Mr. Sazna committed.
Well, as I understood it, and then you'll tell me whether this is sufficient. As I understood it, it's that once the check kiting began, then the loan, when the money was forwarded, the terms began to change, thereby enabling the continuance of the check kiting. So the damages is facilitating the continual check kiting. So that's what I understood. So you can respond by, that's not in the pleadings, you misunderstood that, or you can respond by, that's not sufficient.
I think there's two issues with it, Your Honor. The first is that that's S&T's conclusion. The specific allegations show that Mr. Sazna completed his check kiting scheme by using the overdraft protection and by the fact that S&T was honoring checks that had not cleared. That's number one. And number two, it certainly is not sufficient to show some overarching 52 MCA conspiracy claim.
I don't, any questions from the panel? All right, thank you. All right, yours is the easy because I have a 5-minute in here. Everything else, I didn't have anything that corresponded in here.
I appreciate that, Your Honor. May it please the court, Chad Zipfel on behalf of Appley Knight Capital Funding LLC. As Your Honor indicated, I've been allotted 5 minutes to speak on behalf of my clients. And since Mr. Truitt spent much of his time discussing civil conspiracy and the notice pleading standard, I thought it would make sense for me to spend some of my time talking about the two other claims that appellants are still pursuing, the fraud claim and the tortious interference claim. So the core of a fraud claim, as the court knows, is a materially false representation, and to state a claim for fraud, that materially false representation has to be pleaded with particularity. That has not happened here, very clearly. The trial court issued their ruling, dismissed the fraud claim, lack of particularity. On appeal, it appears that that appellants have largely abandoned that argument, now arguing, and we heard it again here today, that the fraud claim is really at bottom the underlying wrongful conduct that gives rise to their conspiracy claim. It is still in the complaint as a standalone claim. I think it's very clear that it hasn't been pleaded with particularity. There are no materially false representations pled in the complaint being made by the appellees. What the complaint really alleges is that the appellees did regular, ordinary business with Mr. Sosna. That's what the allegations say. There are no underlying material false representations pled in the complaint. Therefore, that one can't survive the 12b6 motion to dismiss. The tortious interference with contract claim also fails. S&T's complaint fails to satisfy three key elements of a tortious interference claim. First, importantly, knowledge of the contract at issue. Second, intentional procurement of the contract's breach. And third, lack of justification. And those first two elements that we'll talk about, as we discuss them, they apply very similarly to the conspiracy claim as well. First, knowledge. The defendants cannot be liable for tortious interference absent actual knowledge or the existence of a contract. S&T failed to plead any facts that could in any way show that my client, Knight Capital, had actual knowledge of its agreement with Mr. Sosna. That's nowhere in the complaint. Nowhere. S&T simply alleges that it filed UCC financing statements and that the MCAs, including Knight Capital, should have known about it. Essentially, that's at best an allegation of construction knowledge, not actual knowledge. Thus, that's insufficient to state a tortious interference claim under Ohio law. Second, intentional procurement. Even if a Sosna entity breached the contract with S&T, there are no allegations in the complaint suggesting that any of the appellees intentionally designed the contract's breach. To show that intentional procurement, S&T has to demonstrate that Knight Capital or any of the other appellees was also aware of the terms of that contract and knew that their business would likely precipitate a breach. That's the Ohio law.
Is there any allegation that there was an event of default before the MCAs took any money from the accounts or during that time?
I don't believe so, Your Honor. It is a 271 paragraph complaint, so I don't have it all memorized, but I don't believe there's an allegation in there that the appellees were somehow knowledgeable of a default by Mr. Sosna or in any way, shape, or form. What the complaint really alleges is that the MCAs did business with Mr. Sosna like they've done business with everybody. That's what the complaint alleges, that they made loans, that those were, they're not necessarily loans, they're purchasing accounts receivable, right? And they do business with Mr. Sosna the same way they do business with everybody. That's the MCA industry. That's what the complaint really is about, is complaining about the way the MCA industry operates. That's what it really is. This is a traditional bank complaining about the way that the MCA industry operates. That's what we've got. So there is no evidence there is no allegation of an intentional procurement in the complaint. There's nowhere in the complaint does it say that Knight Capital or any of the other appellees knew about the agreements between S&T and Mr. Sosna, intentionally did something to cause him to breach it. That's not what they allege at all. What they allege is that they purchased the accounts receivable, and that by the very nature of doing that allowed Mr. Sosna, or Mr. Sosna was then able to use that money to somehow further facilitate his check kiting scheme. How exactly that happened is a little unclear in the complaint, because as my colleague indicated, the real allegation is that checks were written off of overdraw protection accounts and deposited by S&D. Nonetheless, the allegation is that funds from the MCA somehow facilitated that. But there is no evidence, or excuse me, there is no allegation of any intentional procurement. That's a base element of a tortious interference claim. It's not there.
All right, thank you. I do have one quick question.
Yes, Your Honor, of course.
With regard to tortious interference, the complaint allege any resulting damage?
Well, I would admit that in a way it sort of did. They have alleged in an overarching manner that they've been damaged as a result of Mr. Sosna's check kiting scheme. So I would imagine they would argue that. I don't think they've alleged any damages directly related to the conduct of the appellees. Because again, they've not alleged that we knew about those contracts or that we intentionally procured them, or intentionally procured the breach of them. So the complaint
That's
doesn't
why I'm
tie
asking.
other than a baseline.
I'm not talking about the fraud, I'm just talking about
Right.
just the tortious interference, whether there is any allegation of resulting damages as a result of tortious interference.
Other than I believe that other than the bare paragraph that would be at the end of the count in the complaint that says we were damaged as a result thereof, I don't believe it's in there. There are no supporting facts, no supporting allegations to show damages related in any way to the tortious interference.
Thank you.
Unless the court has any further questions, I'll surrender the rest of my time to my colleagues.
All right, thank you. Good morning. All right, again, no issues with the timer.
5 minutes.
You can relax.
Nothing.
I got you covered, 5 minutes.
Right. May it please the court, I'm Paul Carriage. I represent 4 of the MCAs. It's Green Fund of Manhattan LLC, YRB MCA Inc., KeyCap LLC, and Bridge Funding Cap LLC. So I have 5 minutes, and I'm going to try and touch upon 3 issues, but I'm going to do it super briefly as much as I can. First one is, I'm not going to restate what you've just heard. My clients join all of the arguments raised about the pleadings and the standards.
Understood.
The second part is I do want to spend probably the bulk of my time talking about proper application of the standard for a motion to dismiss. And then I think I'm going to touch upon personal jurisdiction. There's an alternative argument raised in the brief. It's just an alternative argument if you're not reversing.
And no one has really addressed personal jurisdiction yet.
I'm sorry?
I haven't heard anyone address personal jurisdiction
Right,
yet.
but I would just rest on my brief. I don't think there's anything I'm going to say that isn't in the
Okay.
brief on that. So let's turn to the pleading standard, and I admit this is a little bit of a steep climb, but I'm going to try and convince you that Ohio has actually always had Twombly and equitable as the standard. So give me a couple of seconds, and I'll try and explain this based on the historical application.
I
of
wish
the
someone
standard.
had told us that.
Yeah, well, so I think someone might have done in very vague language that has slowly been developed over the years. So 1957, Conley versus Gibson, United States Supreme Court, uses the phrase something along the lines of no set of facts. And everybody starts moving forward with this, and Ohio adopted that case, Conley versus Gibson, the 1957 US Supreme Court case. Ohio adopted that in 1975. So since 1975, in fact, in the syllabus of the O'Brien case, which it actually says Conley versus Gibson followed. Now, what happened then is, whatever it was, 30 years later or something, we got this Twombly versus equitable decision. And everybody uses this shorthand of heightened federal pleadings. That's the shorthand we use. But what Twombly did is, well, let me say it the other way around. Twombly didn't change anything. What Twombly did was explain that courts had misapplied Conley versus Gibson, and that the plausibility standard had always been the rule under Conley versus Gibson, and other courts had misunderstood that. And then from now on, apply Conley versus Gibson properly. Now, there's a concurrence written relatively recently by Justice DeWine explaining all of this in much better than I ever could, which is why if you read that concurrence, it will look remarkably similar to one of the sections of our brief, because I basically copied it. Because it seems right that Conley versus...
You practically adopted it. How's that?
Yeah, sure. I would give Justice DeWine more kudos than that, but sure, I'll accept that. So what we get to is the plausibility standard that is explained in Twombly versus Iqbal is not a new standard. It is the standard that was set forth in Conley versus Gibson. And when the Ohio Supreme Court adopted Conley versus Gibson in 1975, the Ohio Supreme Court didn't adopt the misinterpretation of Conley versus Gibson. The Ohio Supreme Court adopted the proper interpretation of Conley versus Gibson. And all Twombly and Iqbal did was explain what that proper interpretation was, which is the claim has to be plausible. We can't have, so-and-so punched me on the nose, and by the way, they also conspired with aliens to do it. So sure, I might have made a plausible allegation of being punched on the nose, but I think we can probably get rid of the alien conspiracy claim, even though theoretically I guess I could prove the existence of aliens. I mean, there is a set of facts, but no one's going to allow that claim to move forward because it's not plausible. So what I think we end up with is the standard in Ohio, we use this phrase notice pleading standard, but all that Twombly did was explain what notice pleading means. It didn't change it to a heightened standard. It explained that plausibility has always been part of the notice pleading standard. And courts, if you read the big chunk of Twombly explaining exactly why Conley used the words it did, and it was basically because there was a whole section before the no set of facts standard saying these allegations are plainly plausible, and therefore it sort of moved past the plausibility analysis before it got to explaining the no set of facts standard, and it was the no set of facts standard that was quoted by a bunch of courts in isolation, and that led to this misunderstanding. So I'm going to try and sum this up in one snappy sentence if I can. Ohio Supreme Court adopted Conley versus Gibson, adopted the correct interpretation of Conley versus Gibson, not the incorrect interpretation of Conley versus Gibson, and all Twombly did was explain that, explain the proper interpretation of Conley versus Gibson. So when Ohio adopted Conley versus Gibson, it really adopted exactly the standard that is explained in Twombly. So if you get to the point where you're doing a de novo review of the claims, because you sort of have this problem with the use of the word plausible, I think that de novo review is done through the lens of Conley as explained through Twombly, not Conley as misapplied. And that's all I have to say.
So that which is pled must be plausible.
Yep.
Okay. So is there anything that's pled that's not plausible in this case?
Well, then you would just go back to what I would just say, like the decision, Judge Branch's decision sets forth the claims that are, Judge Branch applied the notice pleading standard in the, let me get this right
Understood,
around.
but,
Yeah.
but your friend, Attorney Truitt,
Yeah.
basically said this is de novo.
Right.
It doesn't matter if the wrong standard was applied. I'm not asking you for you to remand it for the trial court to redetermine. I'm asking you to determine under the correct standard. You are now explaining to us what the correct standard is.
Yes.
My question is there anything in the pleadings that's not plausible?
Yeah, a 52 MCA conspiracy for people that are never alleged to have discussed anything with each other, that would be not plausible. And like a silent conspiracy, a conspiracy with no communications, that would be not plausible. I think it's a 200-count complaint. We could go through all of these, but that's just an example. The idea that...
So what you're saying is in order for there to be a conspiracy, there must be actual communication about whatever is at hand with the conspiracy. There has to be actually,
Well, I believe the
true
I'm sorry, I interrupted.
communication. There must be a discussion.
I believe the standard is there must be a common goal.
There must be, as partner,
Common goal.
a common goal.
That's conspiracies require a common goal, and that would be absent if there's. Yeah, I think I've satisfactorily answered your question.
All righty.
Okay, thank you so much.
We do have a 3-minute one.
May it please
Although
the
my
court.
battery's low, apparently, I just got a notice on that. The timer and I are not best friends right now. You can start whenever you're ready.
Thank you, Your Honor. May it please the court, my name is Dylan Gould from Markovitz, Stock & DeMarco. I represent Appelli Eincap, Inc. And I join in the legal arguments that have been made here today by counsel for the other defendants. One legal point I would like to make, I think there was a question whether Avery is the only case that's been cited that discusses a specificity standard. I believe in our brief, we do cite another case for a similar proposition, which is Cleland v. Wildermuth. It's a 10th District decision. It's 2011, Ohio 6390, and we cited paragraph 20. And although there's a specificity standard for conspiracy claims in general, here the conspiracy claims are conspiracy to commit fraud. So fraud is always subject to a particularity standard, and the case law in conspiracy to commit fraud claims discusses often how those claims are going to be held to a higher standard than just even a traditional conspiracy claim. Now, I really just want to take a minute to stress, kind of switching gears here, to stress the lack of well-pleaded allegations in the complaint about Eincap specifically. All the complaint really alleges, the only substantive allegations in the complaint about Eincap are that on one occasion in January of 2020, Eincap provided MCA funding on one occasion to Harold Sosna or to some other unidentified entity. It's not really specific. There's really no indication from the complaint that the decision to provide funding was anything other than an independent business decision. Now, the complaint includes, plaintiff tries to suggest otherwise by, for example, including an allegation that Eincap has an office on the same floor of a building in New York City, in the financial district of New York City, as one of the other defendants. But that's not even circumstantial evidence of a conspiracy between the defendants, let alone evidence of a conspiracy between Eincap and Mr. Sosna.
So as I understand your argument is that having shared space, or even if there was shared space, even if there was shared employees, that's not sufficient.
Your Honor, I don't believe there are any well-pleaded allegations that Eincap shares any employees or personnel with the plaintiff. And yes, Your Honor, I think the mere allegation that there was a shared building floor is not sufficient for a conspiracy, and although not directly relevant here today, discovery would show that there was no relation between the parties. And, more than that, the complaint alleges that the money was paid back to Eincap in April of 2020, but any alleged losses to S&T occurred weeks later in May. So any fraudulent conduct by Mr. Sosna that actually caused these alleged losses would not have been for the benefit of Eincap. I believe there was a question earlier about whether there had been defaults prior to these instances of funding, from the conventional lenders. And I don't have the specific paragraphs in front of me, but I do know specifically in the complaint that it alleges that Huntington Bank and FFB declared defaults in February and March of 2020. But again, Eincap's money was provided in January. So at the time Eincap provided funding, Mr. Sosna was still in good standing on these massive loans with multiple conventional lenders.
So just so you know, your time has run. I'll give you 30 seconds if there's any last point you want to make or if you want to wrap up.
Thank you, Your Honor.
Okay.
I'll wrap up quickly. I'll just point out that there are hundreds of pages of exhibits attached to the complaint. Not one of those references or mentions Eincap in any way. Really, all it shows is that one time Eincap provided money to Harold Sosna or some other entity, and that money was paid back before any damages were incurred by S&T Bank. That's not sufficient to state a claim.
Thank you.
Thank you.
All right. All right. If I've done my math right, you have 16 minutes.
Okay.
And there is no 16-minute timer thing here, so
That's, well,
we'll muddle through it.
I doubt I will have 16 minutes of things.
What I've been doing
to
is
say,
just
Happy to
using
answer the
two
court's
entries and having them.
Let me
I
ask
do
you-
want to make, no.
Do you think Ohio has adopted that Twombly standard?
Well, so I was
Is that
going to
what
say
you're-
3
okay.
points. First point is what this pleading standard was. So I think no. The answer is it has not. I think if you look at what Twombly and Iqbal did, it very clearly retired the no set of facts language from Conley v. Gibson that the Ohio courts have adopted. And if you look at federal court cases post-Twombly and Iqbal properly applying that standard, you will not see the no set of facts language. You will not see that standard. I think it sort of blinks reality to say that the Iqbal and Twombly standard is not a raised one from the one that had been applied in federal court. And I think it is a raised one on the one that is properly applied in Ohio courts. Post-Twombly and Iqbal, the Ohio courts, including this one, continue to use the no set of facts language as the standard. As recently in Maternal Grandmother, the Ohio Supreme Court used that language and applied that standard. I think the 8th District decision in Tuleta lays out very clearly that it is left to the Ohio Supreme Court or the rules, a rules change to adopt that higher standard. I think if you look at the DeWine concurrence in Maternal Grandmother, what you'll see is that Justice DeWine was acknowledging that that court had not decided whether to apply the plausibility standard. There are certainly some things that remain consistent. The legal conclusions don't have to be credited. Factual allegations do. That has always been the rule in federal court, and it is the rule in Ohio courts. But the plausibility standard, the heightened plausibility standard, does not apply in Ohio courts.
Well, how would you respond then to your opponent's arguments that both the Avery case and the Clellan v. Wildermuth case, which I'm looking at right now, both of those cases say that conspiracy claims must be pled with some degree of specificity?
So I take that to be a slightly different issue, Your Honor. I think that is about whether it's kind of a Rule 8 or some sort of Rule 9 equivalent. I think they're misreading those cases. If you look at Avery, for example, what the court says there, it's a 6th District case, that there are no facts in that allegation about the damages from the conspiracy. There's no allegation of a tort, an underlying tort in that case. I think they're plucking out a language that I credit you could suggest that there's some sort of particularity requirement, but I think the actual requirement for conspiracy is the Rule 8 notice pleading standard. Rule 9 is about fraud, of course, not conspiracy. And for that, I think you need to allege the object, the purpose, and the damage, and we've done all of that. We've done all of that here. Now, I actually don't think that the court needs to spend a great deal of time on the pleading standard. I do think that's the proper one, and we meet it clearly. But I also think that this complaint passes any plausibility standard as well. Now, just taking a step back, I mean, defendants are clearly on notice as to what we have alleged. You heard them stand up today and say that we allege this conspiracy among 52, it's 51, it's actually a little bit hard to count, how many MCAs. We alleged, we named one in the complaint that then one of the defendants came back and said, no, that's the same entity as us. So it's a little bit hard to figure out exactly how many distinct entities there are here. But they complain that we have alleged a conspiracy among all these organizations. We've alleged that they had access to Mr. Sosna's funds. We've alleged that they've entered into and they've made these advances with the purpose of advancing that fraud and profiting from that fraud. That's true. That is our allegations. That they're clearly on notice of what we have alleged that they have done. They just dispute that they have done it. Now, as to...
Central to that is the knowledge, the access, the knowledge, right?
Yes, Your Honor.
Now, aren't there some of the defendants that didn't have that access and knowledge?
No. So at this stage of the case, we have alleged that they all had that access. You can look at paragraph, 113, we said that the defendants, all of them, logged into Sosna's accounts to schedule ACH payments. We've alleged at paragraph 122 that all of them intensely scrutinized Sosna's and his entity's finances. We alleged at paragraph 123 that all of them were acutely aware of the business's financial situation. And we alleged at 168 that all of them repeatedly informed Sosna that they were closely monitoring all of Sosna's and his entity's bank account history. We have made the allegations that all of them had this access access, that all of them were exercising this access, that they were in agreement and a common plan in order to advance this fraud. And so the question really is, have we met, going over whatever barrier, whatever burden it is, to show that it's not speculative or that it's plausible, depending on which standard you want to apply. And I think we've done both. I mean, this is not a case about the entire MCA industry. At paragraph 126, we allege that all of these MCAs made advances to Mr. Sosna. So this is not the entire industry as a whole. And this is not an allegation about goblins coming down or whatever the metaphor was. This is allegations about an industry that has some bad apples in it. It has been the subject of investigation, has been the subject of allegations.
And I assume that you do acknowledge that simply providing the advances is not sufficient.
I'm sorry, Your Honor?
I assume that you acknowledge, you can say no, okay, that merely making the advances is not sufficient.
I agree, Your Honor. I think for a conspiracy, you've got to have a common plan. You've got to have an agreement, either explicit or implicit. It doesn't have to be an explicit agreement. But I think what the Williams case shows is that when you make an advance or a loan in that case, knowing that what those funds are going to be used to do is to carry out a fraud, that's sufficient to show that common plan and that common design. I think it's certainly sufficient at the pleading stage to get us to discovery, so we can actually get in and understand how these advances worked, what the communications were, what they knew. Eventually, we will have to make our case. Eventually, we will have to prove the allegations that we've made, but they're clearly on notice of what they are, and I think they are more than plausible that that's what occurred here.
So the other traditional lenders, they also lent money to Mr. Sosna, millions and millions and millions of dollars, also had the float. So is there any allegation that the traditional lenders
No, we have not alleged that they knew what was going on. And I think there's a couple different reasons for that, Your Honor. The first is that traditional lenders don't have this sort of bird's eye view, this sort of ongoing access where they can look at all of the accounts of Mr. Sosna at any time, where they can pool the funds at any, on a daily and weekly basis, these large amounts of funds.
So the contract between the traditional lender and Mr. Sosna did not include the access to the accounts.
I'm sorry?
Is that what you're saying?
Yes.
The
So there's
contract
two distinctions, I think. One is, and it's a big one, right, is the access and the knowledge that the MCAs had into Mr. Sosna's financial dealings because of the way they operate.
But the knowledge that you're calling access and knowledge, but as I understood it, your knowledge is an inference from the access.
We actually allege in explicit words that they had knowledge of his financial dealings. We actually allege that they scrutinized that. The question really is that a plausible allegation, right? And I think it obviously is. I mean, if you look at the second thing that distinguishes the MCA, the defendants here, from traditional banks is the series of loans that were made, the increasing amounts, the shortening period, and just the amounts as a whole, right? We're talking about Mr. Sosna, a man who is operating failing nursing facilities.
So let me rephrase my question.
Sure.
So it's the access and the increasing of the terms of the repayment, and I believe also the interest.
The amount of the
amount of the
payment
interest after the check kiting begins is what creates the inference of the knowledge.
I think it's what makes it plausible. I really don't think this court needs to infer anything. We have made the allegations. We have alleged the defendants knew. We have alleged the defendants agreed with each
Okay, then
other.
let me rephrase that. Are there circumstances that support the knowledge?
Yes, Your Honor.
Okay.
That's correct. That's
All right.
Just to say a word about fraud and about tortious interference, and I'm happy to address personal jurisdiction if the court has any questions on that as well. On fraud, we do have a standalone count. The reason we have a standalone count is because, for two reasons. Below, of course, we alleged both that they are responsible for Mr. Sosna's fraud that no one disputes occurred, and that's because of the conspiracy, but that provides for a separate cause of action for fraud against the defendants. They are liable under Williams for their co-conspirators' fraud that no one really disputes what's occurred here. Below, we also alleged that there was a separate fraud from the MCAs, by the MCAs, that is the misrepresentations, the concealing of their loans by holding back the UCC filings. We haven't rested on that here. We haven't abandoned that, but I think it's sufficient for our fraud claim that we have alleged and plausibly alleged a conspiracy that makes them liable for Mr. Sosna's fraud. As to the tortious interference, Your Honors, I think we again have made the allegations sufficient to make out a claim for tortious interference, and they are on notice that that is what we have alleged. I think there was a question about the damages.
There's a question about damages, resulting damages from the tortious interference.
Correct. So I think,
question.
Right, and the damages that we have alleged, you can look at, it's paragraph 270 of our complaint, and what we said is they have deprived us of our collateral. They have taken all of the accounts receivable that we had a priority interest in a way that once the inevitable default came from Mr. Sosna, we could no longer collect on that. And they did that knowing that we had a priority interest on that, on the accounts
But
receivable.
at the point that they took that money, there was no event of default, correct?
There had not been an event of default, that's correct.
So if
At least it's the allegation.
okay, so if there was a lender or any sort of creditor who took from that account, let's put the MCAs aside for a second, that took from that account knowing, if they actually knew that there was a security interest there before an event of default, how would that translate to interference?
So I think you've got two different things going on there. I mean, one is the conduct that you actually damage us, and I think there's a distinction here in that we've alleged a conspiracy. They are working together, and they are draining these accounts of any value, not just exercising one withdrawal, but a series of daily and repeated withdrawals that drain them of account. Two, they have the knowledge of the priority interest. And then three, I think what's important here is that tortious interference has to be unjustified. And so I think the court does have to say, have we plausibly alleged that what they did here was not justified by their own business interests? And I think we've made that case, at least at the pleading stage, that it's fine to exercise your loans when you're not acting in conspiracy to further this series of loans and advances that suck these things dry of any value. It is not justified when what you're done is work in conspiracy to allow and to benefit from this series of loans, from the misconduct by Mr. Sosna, and pull that money in, leaving us with no collateral at all.
Thank you.
If there are no further questions, I'll just close with this, Your Honor. I think what was clear from the briefing and from the arguments is that the MCAs deny our allegations. They think it's not plausible. They think they're not in conspiracy together. They never were. They were merely exercising their business. They're, of course, entitled to deny all of these allegations. I think there's no doubt that they know what we've alleged, and I think the problem in this case is that we haven't had the ability, the fair chance, to get discovery and to prove those allegations. At a further point in this case, if we can't prove them up, then they can defend and individual MCAs can get out of this case. But for now, I think we have made the showing that's required by Ohio law to get just to discovery and to have a chance to prove our case. So I'd ask the court to reverse. Thank you.
All right, thank you. Thank you to all counsel for your arguments this morning. We will take the matter under submission, issue you a timely decision, and I wish everyone a wonderful afternoon and a great week. And with that, that concludes our proceedings for today. Thank you.